Vasu, this meeting is also live streamed.
Oh, okay. Right.
I think in YouTube.
YouTube. Oh, right. Fine.
Shall we start?
How many are there? 30 Irka. Should we wait?
529.
Right.
Yes.
Yes, we can start.
We will begin the meeting. I am Sridhar, President of the RBA. Welcome to all. My sincere thanks for those who responded to my invitation. Today we have 4 speakers. Girish will speak and present a paper on faceless assessment. It will be a very short presentation. He is a young lawyer and requested him to collate the interesting judgments of the various high courts under faceless regime. Then Mr. J. Srinivasan will speak on input credit under GST regime, and he is a chartered accountant. This is a part of a lecture series on GST topic, and this is the 6th part. And thank you, Mr. Srinivasan. Thereafter, we are lucky to have two young minds from Delhi. Both of them attached to Cyril Amarchand Mangaldas. One is Reema Arya. She is a chartered accountant, and VP Tangadurai, advocate. Both of them will present the interesting issues on mergers and acquisitions. I have gone through the personal data of both the speakers, and it is very impressive. RBI is wholeheartedly thank both of them for accepting the assignment to speak today. Thank you, Reema, and thank you, Tangadurai. There will not be any question and answer session today. Those who are keen, we share the papers prepared by the speakers in due course. Now I request Vasudevan to take over.
Yeah. Good evening to all. Our first day for the topic is input tax rate and GST. Mr. J. Srinivasan, Chartered Accountant, is the speaker on the topic. Mr. J. Srinivasan, a short introduction about him. He is a partner in SMCS Global and a partner at NV Balaji & Co. He has been a part of the national team dealing with tax controversy and dispute resolution at PwC. And he is an inter-tax faculty of CA Inter and Final at Sriram Coaching Point, and he is a visiting faculty at many other institutions. So we have a very expert expert person on hand to take us to the input tax rate and GST. Earlier 5 topics were being delivered by Mr. T. R. Srinivasan. I think J. Srinivasan is also equally versatile in the subject. Now I hand over to Mr. J. Srinivasan.
Thanks for the introduction, sir. And I sincerely thank the association for granting this opportunity. I think probably we'll directly go to the subject matter of discussion today. So today's subject matter of discussion is on input tax credit. Now, the topic as such is very, very vast in nature, because if one looks at the litigation before the various high courts, you can broadly divide into 2 to 3 categories. And one such category where there is a significant amount of litigation is input tax credit related issues before various high courts. So therefore, even from that perspective, this topic assumes a large significance. So, I mean, can you see my screen? Is my screen visible?
Oh, yes, it's visible, sir.
Yeah. So now, before starting with the subject matter, some brief, basics about provisions in the GST law. So section 16 to 21 of CGST Act 2017 deals with provisions relating to input tax credit. And of course, in rules, you have rule 36 and 45 of CGST rules, which deals broadly with the provisions of input tax credit. So the subject matter of discussion is broadly divided into these categories. The first part will deal with eligibility and set off. So who are eligible to take input tax credit and what is an input tax credit? And second part is conditions. What are the conditions that one has to satisfy in order to take input tax credit? Third part is there are some circumstances where law prohibits a person to take input tax credit. Fourth is there are some circumstances which warrants a reversal of input tax credit. And lastly, there are some special circumstances. We will deal with each of the topics very briefly. Now, before entering into the relevant provisions, I would like to start with one issue, which is what you call a constitutional issue, whether input tax credit is a vested right. Now, this has been, see, what happens is there are two schools of thought. One is first of all, what is input tax credit? Let me just give a brief of that. So any person who is registered under GST, whatever services he may provide, or whenever he sells some goods, he is supposed to pay output tax. Now, so with respect to the sale that he makes, naturally he will purchase the relevant goods.
1 minute. Somebody is on the speaking over. V2040, who is that? Please mute yourself.
Requesting all the participants to mute your mic.
Thank you. Can continue, sir.
Yeah. So we will now discuss a predominant issue with respect to basic point about input tax credit, whether it is a right or not. Now, before that, I would just like to give a brief on what input tax credit is. It is nothing but taxes paid on all your inputs. So let us assume I'm a chartered accountant, you're a lawyer. So if you are providing service, obviously you would require a place where you will be paying some rent. So for the services that as a chartered accountant I render, naturally I will charge something called as GST on my service. With respect to all the expenses that I incur, whatever I incur in relation to my business, those are all my inputs, to put it simply. Now the question is, on all those inputs, let us say rent, let's say purchase AC, let us say I purchase some stationery. On all these items, naturally, my supplier will charge GST. From whomsoever I avail this service, he will be charging GST. So this GST that is being charged on all the inputs that I use for my service is called as input tax credit, to put it simply. I think there is some noise which is coming.
Sir, please mute, sir.
Yeah. Now, so therefore, this is broadly what input tax credit means. Now, the question is, this is a benefit which the government is giving to you. So if I charge, let's say my client 1 lakh rupee as fees, I will charge along with GST 18,000 rupees. The question is, when I adjust, so I have to pay to the government 18,000 rupees.
Live stream.
Can someone mute?
Mr. Shekhar, please mute.
Yeah. Now, the question here is, so when I charge my client 18,000, I will not pay 18,000 to the government. I will pay 18,000 minus whatever input tax credit that I have, whatever GST that is being paid by me for services that I already used. So this is a benefit. I will not remit 18,000 to the government. I will remit 18,000 less what GST I have paid on my expenditures. The question is this benefit a vested right or not? This question assumes a lot of significance, because if one says that it is a vested right, then what conditions can be stipulated against that right will be the next question. So this is an issue not only under GST, this has been an issue right from your VAT days, right from excise days, etc. I would like to broadly or briefly cover 1 or 2 decisions in this regard and then leave it to you. And I just want to communicate that this is an issue, ongoing issue, probably Supreme Court as late as 2019 has held that it is not a vested right, but still there are some decisions which were not considered in that particular decision. So therefore, it is still open as to whether it is a vested right or not. So the latest decision is TVS Motors Company Limited. This is in the context of Tamil Nadu VAT, where the Supreme Court has observed that ITC, sir, can someone mute? So basically, the latest Supreme Court decision on the subject matter 2019 in the context of VAT says the input tax credit is some form of a concession provided by the Act. It cannot be claimed as a matter of right, but only in terms of the provisions of the statute. This is this is an important and a critical observation, because once you say that it is only privilege provided to you by the government and it is not a matter of right. So if provision stipulates lot of conditions through rules, etc., you are bound by that, is the indirect meaning of it. So this is what Supreme Court has said. And it has also said there was no right inherent or otherwise vested with the dealers to claim the benefit of ITC, but for section 19 of the Act. So therefore, this decision categorically states that it is not as a matter of right that you can claim input tax credit. You are bound by the provisions of the statute. This discussion is very critical because in many circumstances, what happens is there are certain conditions which are stipulated for input tax credit where it may be almost impossible for you to comply. I'll just give you a classic example, which is a subject matter of litigation across the country. So one of the conditions says if you want to claim input tax credit, your supplier should have filed the returns. Not only that, you should also ensure that your supplier has remitted the payment of tax. Now, practically speaking, there is no mechanism available to see whether my whatever GST that has been collected from me, whether it has been deposited into the government's kitty or not. Suddenly, department issues a notice saying that your supplier has not deposited the taxes with the government, where I don't have any access to my supplier's information. Naturally, he will not share. So therefore, these kind of conditions, whether it can be stipulated or not, is a subject matter of litigation across the country. But the underlying factor which provides for these litigations are whether it is a vested right or not. And in fact, there are contrary decisions saying that it is a vested right, which I would like to present, where in the case of Siddharth Enterprises versus the nodal officer, Gujarat High Court has made one important observation where it says with respect to transitional credit. So when the GST was introduced, so people from excise, VAT, etc., they were transitioned to GST. Whatever credits that they had in their returns, they were able to transfer it from VAT or service tax to the GST. Now, there are two important observations which they have made. The observations are as follows. It says the entitlement of credit on the purchases made in the pre-GST regime, as per the then existing SENVAT credit rule, is a vested right, and it cannot be taken away by virtue of Rule 117 of CGST rules. And it was further stated that right to carry forward credit is a right or privilege acquired and accrued under the repealed law, and it has been saved under section 174 of the Act, and therefore it cannot be allowed to lapse under Rule 170. This is a very critical observation because through rules there are a lot of restrictions which are being imposed. Now, whether on the assumption that it's a vested right, can we take a position that such a vested right cannot be taken away through rules or by virtue of rules, is something which I want to put across to you. And we have, the landmark decision in the Eicher Motors 1999, where very clearly they have said whatever input tax credit, whatever taxes that you have paid on your purchases is deemed to be tax paid and it is vested on you. So therefore, there are some decisions where it has been held that it is definitely a right. But of course, after the 2019 decision of Supreme Court, there is definitely two sets of thoughts on whether it is a vested right or not. I just want to put across this to you because this is a constitutional issue which probably should be settled by the Supreme Court. Though there is a decision in 2019, I feel that certain decisions were not considered when the decision was given, and probably a larger bench of Supreme Court might have to settle this issue. right? So this is with respect to Asian Motors, where they have said ITC is a vested right. No demand can be made for recovery that was validly earned by the associate. So therefore, these precedents we have even in Adford Technologies Private Limited, where this specific Eicher Motors case was cited. So therefore, still there are courts taking a view that it is certainly a right. So now this is a basic point which I wanted to discuss. Now let us directly dwell into the subject matter of discussion of today, section 16 of CGST Act, which talks about input tax credit. I would just give you a broad outline of how you have to look at the provisions and have an understanding about the provisions. There are two sets of provisions. One is section 16, which provides for some basic conditions if you want to avail input tax credit. And there is section 17(5) of CGST Act, which blocks input tax credit. That is, you cannot take input tax credit under certain circumstances. I have just given you one sample, what you call a reference as to how you have to read these provisions. So with respect to the provisions of 17(5), where you cannot take input tax credit, you have to look at those provisions. You have to read the provisions as it is and decide the eligibility. Whereas section 16, which talks about eligibility of input tax credit, beyond language, you must also look for the purpose and decide the eligibility, because that is where all our discussion about rights being vested, etc., comes through. And the language used in section 16 is not very clear. So some of the terms used in section 16 is not clearly defined. So therefore, you must look through the purpose and decide the eligibility of credit. Whereas 17(5) has precise language. Therefore, you have to look at the provision as it is and decide the eligibility. This is something which I wanted to convey before, the manner in which you have to read through the provisions. Yeah. Now, let us directly go to the basics about input tax credit. There's a definition for input tax, which is given under the GST law. It defines as follows: input tax credit in relation to registered person means central tax, which is nothing but your CGST, state tax, which is nothing but your SGST, integrated tax. So you all know that if you are doing a transaction within the state, intrastate, CGST and SGST will be charged. If you are going to do an interstate transaction, IGST will be charged. So all these taxes come within the purview of the term input tax or union territory tax if it is union territory, charged on any supply of goods or services or both made to him, and includes, this is what is important. So normally what we understand is any taxes that I pay on my inputs, being CGST, SGST, IGST, everything is an input. Includes IGST on imports. Now you have to understand the imports, IGST on imports is actually levied in accordance with the customs law. It is also collected in accordance with the customs law. But GST law very clearly says, though it may be collected and levied in accordance with the provisions of customs law, it is still considered as input tax for the purpose of GST law. Third, tax on reverse charge under section 9(3) and 9(4) of CGST Act. Now you will be aware that the services rendered by the lawyers under certain circumstances, lawyers need not pay tax. Instead, the person who is receiving the service has to pay tax. Now, when they pay the tax, that tax is called as tax on reverse charge. Normally, the suppliers will be paying the tax. In certain circumstances, recipients will have to pay tax. That is called as reverse charge tax. All the taxes paid under reverse charge under section 9(3), where advocate services are covered. 9(4) is services rendered to an unregistered person. So that also the recipient of service has to pay tax instead of the supplier. So reverse charge also, tax paid under reverse charge is also constituted as input tax. Can someone mute? And lastly,
Mr. Meghanathan, please mute yourself.
Meghanathan, NKR, please mute.
Yeah. So therefore, and lastly, tax on reverse charge under section 7(3) and 7(4). This is nothing but taxes like taxes paid on your import of services, etc. So broadly, this is what the definition of input tax includes. So basically, any taxes that we pay on anything that we use in our business, right, will be considered as input tax credit. So now, I'd like to go to the next subject matter of discussion, which is highly litigative. See, the framework of GST law, if you look at, there is central legislation, that is Central Goods and Services Tax Act. There is state legislation, State Goods and Services Tax Act, and you have IGST, Integrated Goods and Services Tax Act. There is a very critical point, which is a subject matter of litigation where there is no clarity at all. Now, before that, I would just like to highlight one basic point about input tax credit. Now, let us assume I am a chartered accountant. I render services, let's say, to a person located in Karnataka. I am located in Tamil Nadu. So what I will charge is, I will charge IGST because it's an interstate transaction. Now, I definitely will be having input tax credit. That input tax credit could be in the nature of CGST, it could be in the nature of SGST, or it could be in the nature of IGST. The law provides the following rule for using my input tax credit. The rule is very simple. You can use your CGST credit, you can use your IGST credit, you can use your SGST credit in order to settle your IGST liability. Likewise, let us assume this is example number 1. I render services to a person located in Karnataka. Example number 2. I render services to a person located in Tamil Nadu. The GST that I will charge will be CGST and SGST. Now, against CGST and SGST, what input tax credit can I use? I can use all input tax credit except, let us assume I have CGST liability. I cannot use SGST credit for that. For SGST liability, I cannot use CGST credit for that. So therefore, simply put, except for a combination of CGST against SGST and SGST against CGST, all other permutations and combinations are possible. In other words, if you have GST liability, right, except for CGST liability against SGST credit, SGST liability against CGST credit, all other permutations and combinations are possible. This is as per the provisions of GST law. The critical question is this. It's an important question. Now, I am a service provider. I have raised an invoice where I have charged CGST and SGST. Now, when I say SGST, please understand each and every state has an enactment of the respective states. Tamil Nadu State Goods and Services Tax Act, Karnataka State Goods and Services Tax Act. The question is, I stay in a hotel in Karnataka. He has charged CGST and he has charged Karnataka SGST. Please understand, CGST and Karnataka SGST is what he has charged. Now the question is, I am having a local service where I have issued an invoice of CGST and Tamil Nadu SGST. The question is this. We all know I can use SGST credit against SGST liability, CGST credit against CGST liability. The question is simply this. I have an invoice with me of Karnataka's SGST and CGST. Can I use Karnataka SGST against Tamil Nadu SGST? This is question number 1. Question number 2. Can I use CGST paid locally in Karnataka? There is no distinction between CGST paid in Tamil Nadu and CGST paid in Karnataka. Whether I can take credit or whether I can use CGST of Tamil Nadu against CGST of Karnataka. CGST as such does not have any distinction between Tamil Nadu and Karnataka because CGST is single legislation which is applicable across. The levy of CGST is common across the country. So therefore, the question is this. Now, as of now, I'll tell you what is the practical issues. Department by default rejects all claims where you are using SGST credit of Karnataka against SGST payable of Tamil Nadu. But if you strictly go by the provisions of law, there is no bar in you claiming because the provision does not restrict this type of availment of credit. It only says if it is an SGST credit, you can use, if this is SGST liability, you can use SGST credit. If it is a CGST liability, you can take CGST credit. So as of now, department, in some cases, even they are going to an extreme where they are not even allowing the CGST credit where I have paid locally in Karnataka, right? Against what you are, against the CGST liability in Tamil Nadu. So this is the present scenario and it has to be challenged and it has been challenged. And there are some decisions also in that regard. But I have just quoted one Tamil Nadu, West Bengal AR, which has very clearly said that you cannot do that. I would just like to quickly go through this particular decision because this is an issue where assessees on the safer side have taken a very conservative view that they will not use this credit. But in my view, you can take credit because law does not prohibit. Because otherwise, no one nation, one tax, seamless flow of credit definitely will get defeated. So therefore, I don't think the intention of the law was never to restrict these types of credit, where some other state you pay credit and there is liability in some other state. So I would like to quickly go on read this particular decision. It says, as input tax credit and its credit note always linked, whether the person is registered or not, two components of GST paid on inward intrastate supply in Tamil Nadu. This example is vice versa. In Tamil Nadu, I have paid some GST on my inputs. In Tamil Nadu, could have been taken credit off if only registration is taken in Tamil Nadu under Section 25 of GST Act and is regarded as distinct person within the meaning of Section 25. The observation says the architecture of GST Act is such that even if a person is registered in different states, all such registrations will be treated as distinct persons. Now we are dealing with a situation where there is one company, there is only one PAN number, but across the states that company has branches. Now the question is, within the branches, is it possible that there is Tamil Nadu SGST credit? Can I use it against West Bengal SGST payable? Is the underlying question here. The observation says architecture of GST law is such that even if a person is registered in different states, all such registrations will be treated as distinct persons. An input tax credit in the credit ledger of one person is not transferable in the credit ledger of another. If the person is not registered in a particular state, the tax paid on inward supply in that state is not input tax in relation to the said person. That's a very, very important decision where they have gone to an extent of saying that I do not have a registration in West Bengal. I have registration in Tamil Nadu. If you have registration only in Tamil Nadu, please forget about whatever local taxes. GST is one tax only, but the observation has gone to that extent, saying that it will be treated as taxes paid within that state unless you have registration in that particular state, right? And you are using it against the output tax of that particular state. You cannot take input tax credit of that. So in some substance of the issue I'm discussing is, if you are in a particular state where you have paid taxes pertaining to some other state, it is not possible, at least practically department will object, for you to use the credit that has been paid in some other state in the state in which you are having registration. This is something which is very, very important, where as of now, there aren't many high court decisions in that regard. Certainly it has to be challenged, and this will be a very big litigative issue in my view. Right now, let's proceed further. So I'm just quickly running through the basic conditions with respect to Section 16. So Section 16 broadly prescribes some basic conditions if you want to avail input tax credit. So the conditions are as follows. The primary condition is a person has to be registered. If you are not a registered person, you cannot take any input tax credit. That is a very basic point which you have to understand. The critical point is this: when I can take input tax credit, I can take input tax credit when I have used those inputs in the course of business or furtherance of business. So which means I purchase something for my personal purposes. I cannot use the GST that is being paid on that. It has to be in the course of business, or it has to be in the furtherance of business. The only issue is the term course of business or furtherance of business, it is not defined. Therefore, it might lead to some ambiguities, especially companies which are, providing what you call, let's say it provides some facilities to employees. It provides some facilities to directors. Now, one might definitely say that only for the sake of retention of employees, they are doing that. Therefore, it is certainly for the furtherance of their business. On the other hand, department is taking a view that no, you cannot take credit because it is for the personal consumption of those employees. So therefore, definitely this term, which is in the course of business or furtherance of business, since it is not clearly defined, it might lead to litigation. And in fact, there are a lot of notices which has been issued on especially those expenses which are incurred for employees and directors. Now, therefore, this is a primary condition. Unless you satisfy this condition, you are not eligible for any input tax credit. So therefore, that is the basic condition. There are further conditions condition number 1 is you have to be in possession of a valid tax paying document. So it is not only sufficient that you are using it for the business, you should have a valid tax paying document, which is called as tax invoice, e-invoice, etc. That is a mandatory document which you should have in order to claim input tax credit. Second, goods or services are received. So unless you receive the goods or services, you might have a valid tax invoice. Unless you receive the goods or services, you cannot take input tax credit. Third, tax on such goods are deposited with the government by the supplier. In fact, this third condition is the subject matter of litigation across various high courts. Now, the problem simply is this. The provision says tax on such goods are deposited by the government, by supplier. Now, tell me frankly, I have paid the invoice value and I also paid GST to my supplier. Now, what is the mechanism available under the GST law to ensure that he has deposited the tax to the government? There is actually no mechanism. It is impossibility of performance, I would say. It is not possible at all. So therefore, based on this particular condition alone, there are n number of notices which are being issued to assessees saying that, see, what happens is once the department comes to know that a particular person has evaded taxes, he has collected taxes but has not remitted. Simply what they will do is all the invoices he has raised on various customers, naturally he will give notices saying that whatever credit you have availed is not eligible simply because your supplier has not remitted tax. Now, department has that information. How do I have that information? I can probably get a confirmation whether he has paid GST or not. Beyond that, I don't have any access to GST portal to see whether taxes have actually been paid or not. But then department do not agree with the view. So long as they are able to substantiate that supplier has not paid tax, they just demand this tax along with interest and penalty. This is a very critical issue which has been a subject matter in various high courts. Most of the high courts have held in favor of the assessee as long as the assessee is able to prove his bona fide. So if the assessee is able to prove on a bona fide basis that he has remitted the taxes to the supplier, he has valid tax invoice, he has all the documents. However, because the supplier has defrauded or supplier has not deposited, if that is the reason why you are giving the notice, it is not valid, is what has the high courts have said. Right. So therefore, this is third condition where there are a lot of litigations. The fourth condition, naturally, I have to file my returns. So therefore, as a recipient of input tax credit, I have to necessarily file my returns. Now, in fact, we have to go to our original discussion for this condition. See, there are rules which are being prescribed saying that, so before going into the rule, so in GST, how it works is, let us say I receive an invoice from a supplier. So he is supposed to file a return. What is that? GSTR 1, where he will declare that he has sold to me in GSTR 1. Now, in the present system, how it works, it directly hits my portal. In my GST portal, there is something called as GSTR 2A. So whatever he files, it automatically gets reflected in GSTR 2A. Now, one of the conditions says the supplier has to file his return. Only if he files the return and it is getting reflected in your GST portal, you can take credit. You may have the invoice, you might have made the payment, you might have received the goods, everything you might have done. But still, if whatever he is filing, it is not reflected in your dashboard, then you are not entitled to take credit, is what the provision says. And against this very provision, there are challenges because for the fault of the supplier, see, I have made the payment, I have valid invoice, I have all the documents with me. Just because there is a fault from the side of the supplier, can I be penalized? Is an issue. This has been challenged. So constitutional validity of this provision also has been challenged. So now in this context, there are some rules which were issued. So 2019, 2018, 19, 2021, they said if your supplier has filed the returns, let us assume total amount reflected in your dashboard is 100 rupees. You can take credit up to 110 rupees. You can take credit up to 120 rupees. These are all things which are being prescribed through rules. The question is simply, can the government prescribe such value in rules? Basically, they are saying that you might have satisfied all the conditions, but I will still restrict your input tax credit to so much of credit plus
Yes, sir.
some percentage, whatever is reflecting in your dashboard. So these are all questions where there is no answer, but there are some writs which have been filed, especially in Gujarat High Court and Bombay High Court, where the notices have been issued to the government saying that they have to respond. So constitutional validity also has been challenged with respect to various rules, which provides some restrictions with respect to input tax credit. Right? So there are some.
Srinivasan, 5 more minutes, Srinivasan.
Yeah.
Hello?
So with respect to other points which I want to highlight, again, this is an area of litigation. Look at this provision. Second, someone mute the other.
It is under Robert Foley 20.
Sir, please mute, sir. Please mute.
Only
Don't
salary.
disturb the meeting, sir. Please mute. How
2000.
many times I'll inform you people? Please mute.
All the 12 months. No, you
Now,
just pick it up.
The next subject matter which requires a lot of study is, again, this is a subject matter of dispute. Some writs also have been filed before the High Court. There is one condition which says, if I do not make the payment to my supplier
Just only checking.
within,
That's why I told her, I have seen. You need not prepare.
Sir, please mute, sir. Please mute.
yeah. Now, there is one more condition which certainly requires challenge, is this condition which says, if I have not made the payment to my supplier within 180 days from the date of invoice, the provision says, I have to reverse the input tax credit. Now look at this provision. It does not talk about GST payment. It says, let us assume there is an invoice which is given to me. The invoice has 10 lakh rupees and GST is 1.8 lakh rupee. It does not talk about GST component. It says, if you have not made payment of 11.8 lakhs to your supplier within 180 days, you have to reverse the credit that you have taken. Now, already, I do not even understand the logic of why there can be such a provision, because once you remit the payment of GST to your supplier, naturally he would have remitted to the government. Government is not losing anything. So how can a GST law, which is basically a fiscal law on taxes, where they have collected the taxes, but I have not made payment in respect of my service. Probably I enjoy a furthermore credit period. He is not at all bothered if I pay in 200th day, 300th day, etc. How can a provision say that if I fail to make the payment, that is payment towards service, along with GST, I have to reverse the credit? This again has to be challenged, because I don't think this is a fair provision, because government has already received the GST. On the one hand, I'm taking input tax credit. On the other hand, supplier is making the payment of GST. But still, there is this provision which talks about one of the conditions for claiming input tax credit, which has to be challenged. So this is with respect to other special points which I have to mention. And this point about depreciation on capital goods, you have to be careful. If you claim depreciation including GST, you cannot take input tax credit. Therefore, if you are claiming depreciation, please ensure that you don't claim depreciation including ITC. You take the ITC separately. And whenever goods are being received in lots, naturally only at the last lot you can take credit. These are some special points which I want to highlight. Now, just two more points which I want to say and conclude. So, with respect to receipt of goods or services, as I said, this has to be completely challenged. It says more than 180 days you have not made the payment, you have to reverse the input tax credit along with the interest. So, this naturally has to be challenged. Of course, as and when you make that payment, you can reclaim the credit. That is fine. But then on the first place, there can never be a provision like that. And last point with respect to input tax credit is on the time limit for availing input tax credit. So naturally, any right which is given, naturally there will be some time limit which will be provided. So in fact, very recently it has been amended as well. Till last year, the time limit was, let us assume there is a financial year 2021. So you have to claim the input tax credit by September 2021 returns. So every return that you have to file is due date is 20th of succeeding month. So the due date for September 2021 is 20th October 2021. So you are supposed to claim all your input tax credit pertaining to April 22, March 2021 by 20th October 2021. That is the last date for availing input tax credit. There is an amendment to that section which has extended the date from 20th October to 30th November. So, and there is something called as annual return which you have to file every year. So the due date of furnishing returns or actual date of furnishing an annual return, whichever is earlier. So this is the last date within which you have to have an input tax credit. Here again, I would like to highlight one critical litigation point. There, supposing let us say there is 2 or 3 days delay, or let's say 1 or 2 months delay, and there is a genuine reason why there is a delay. Whether it is possible for us to argue that despite the fact that I have taken input tax credit beyond the time limit prescribed, if the credit is still eligible, this is again a litigation, because there are certain arguments which are taken that once you pay late fee or interest, the delay is being compensated. So to that extent, once you pay late fee, whatever credit you avail has to return back to the original due date. So this is again a litigation point which I wanted to highlight. And there may be some genuine cases. I mean, this also some writs have been filed where because of health reasons or otherwise, the person is not able to take credit within the stipulated period. Courts have definitely granted some relief. But I want to highlight this point. Consistently, Supreme Court has held and some various high courts have held that with respect to time limit, they are very, very strict. If you take credit beyond the time limit, they do not give any leeway whatsoever. So therefore, with respect to time limit, you have to be very, very careful unless there is a strong reason for you to take credit beyond the stipulated period. I don't think you will get relief at the highest level. So therefore, it's very, very important that we understand that particular point, because right from excise, VAT, etc., this has been a subject matter of litigation, and it has been held in the favor of department only. So therefore, this again leads to the original discussion whether input tax credit is a vested right or not. If you conclude that it is a vested right, then probably the argument to say that time limit, though it has expired, I can still take credit, will have a stronger ground. I think the time allotted to me is completed. So therefore, I would like to conclude here. We will continue this discussion in the next sessions. Thank you.
Thank you, Mr. Srinivasan. It's an excellent presentation. Thank you so much. On behalf of RBA, I once again we have said that we are grateful to you. Thank you very much.
Thank you.
Now I request Girish to take over for the next 10 to 15 minutes on the interesting judgments on faceless assessment regime under the Income Tax Act 1961. Please proceed, Mr. Girish. He is a young lawyer, and I hope that he will put up a good show. Thank you very much. Yes, Girish.
Good evening, everyone. I'll be presenting on case studies relating to National Faceless Assessment Center. So these are the cases decided by High Court on the decisions made by National Faceless Assessment Center. So in this era, in this electronic era, it is always a necessity to adapt to the new electronic era, and National Faceless Assessment Center was introduced with the intention, with the same intention. Sorry, that's a technical glitch. So during the period of transition and adaptation, there will be some glitches, some problems, some failure to adaptation will be there, either intentional or unintentional. But there will be some transition period to adapt fully to the new regime of National Faceless Assessment Center. So these are the cases that are that are not 100% on mark due to the failure to adapt to the new assessment center. So I'll be going to the cases now. These are the cases related to issuance of show cause notice, where I will be dealing with 3 subtopics. The first one will be where there were no draft assessment order or show cause notice was issued, and I'll begin the first. So this was a case in Delhi High Court. YCD Industries was NFAC. In this case, draft assessment order itself was not served on the assessee, even when there was a variation in the order. So the Delhi High Court set aside the order decided by the National Faceless Assessment Center, asking them to issue a show cause notice to established the case of the assessee. Similar judgment was rendered by Delhi High Court in the case of low-case constructions, where 14 lakhs variation was proposed by the National Faceless Assessment Center, and the assessee came to know about it only during the passing of the assessment order. The second one would be a time limit. This is a case decided in the Madras High Court. Anthony Alphonse, Kevin Alphonse as ITO. In this case, notice was issued on 4/3/2021, prescribing time limit, setting the time limit to 15/3/2021, asking the assessee to submit his judgment before 15/3/2021, 11:59 p.m. The assessee made his submission on 15/3/2021 within the time limit, but the order was passed on the same day, that is on the 15/3/2021. The High Court decided that since the order was passed before the time prescribed for filing the reply, it is evident that the impugned order has been passed with a preset mind. So for this reason, the Madras High Court quashed the assessment order. In Egambram Sugumaran versus ITO, similar set of facts, similar judgment was passed by the Madras High Court. In Raja Builders, in addition to the same set of facts, there was also some glitch. The third problem relating to SCNs was that the time limit allotted was too short. In all these cases that I will be referring from now, the time limit allotted by the NFAC was too short. In KBB Nuts versus NFAC, the show cause notice was issued on 24/2021, and the time limit was to file its responses 21/4/2021 by 11:59 p.m. The assessee appeared before the NFAC and asked for adjournment. He filed adjournment via the portal and asking for adjournment till 22/4/2021. But the order was passed on 22/4/2021 after receiving the submission of the assessee. But the court decided that when the order was passed on 22, when assessee's request for adjournment was not dealt with by the NFAC, and the order was passed, even though the revenue stand in this case was that I waited till 22/4/2021. That is the request of the assessee through the adjournment filed. I have satisfied his requirement. The High Court disagreed with the NFAC and passed the order in favor of the assessee. In Kumaran Silk Traders was ITO. One day, 24 hours time was given for replying, and it is decided by the High Court that it is violation of natural justice. I'll be moving to the second problem faced during the NFAC. I'm sure many of us will have faced this problem. So, by Finance Act 2022, this section 144 B subsection 6 clause 7 was introduced, where the request for personal hearing is mandated by the act. Previously, before the amendment, the request for personal hearing was not mandated by introducing the word shall allow. Earlier it was may allow. I'll be moving to the first case, Chandubai Danabai Vagela versus NFAC. In this case, the important point that is established by the court is that it is not for the assessing officer to decide whether the video conference is necessary or not. This case is post-amendment. The argument of the revenue during the arguments was that there is no new submission which need to be examined, and hence the VC is not necessary. Various submissions were placed by the assessee, and various opportunity was given for him to place his submissions. He still requested for a personal hearing, which was rejected by the NFAC. But the court decided that it is not for the assessing officer to decide, thereby establishing that assessing officer has no say to decide whether video conference is necessary in a case or not. It is mandate. The second case is case decided by Supreme Court of India in Sapna Floor Mills, where the video conference request for video conference was placed before the NFAC, and NFAC, after acknowledging the adjournment request filed by the petitioner, still rejected the adjournment without granting any reason to the assessee. So for rejection of personal hearing, there should be first of all, it is not for the assessing officer to decide, but after acknowledging the request, this shouldn't be done, and denial of such opportunity of has no reason, and the court decided that it is found to be in violation of principles of natural justice and set aside the case. The third case would be Bharat Aluminium Company versus Union of India. It is decided by the Delhi High Court. The third case is a amendment scenario. In that case, the respondent argued that grant of personal hearing is, if everyone asks for personal hearing, then it would be a routine or stereotypical manner which would frustrate the faceless assessment center, which in turn would make the NFAC a failure. That was the argument of the respondent, since the core of the National Faceless Assessment Center is without any human intervention, the case has to be decided. In a pre-amended scenario, as I said, it was may grant opportunity was the wordings in the act. The court decided that if personal hearing was not given, then the assessee would be deprived of an opportunity to clarify the doubts of the assessing officer / decision maker. In this case, the court even went further by stating that even if the word may was present in the section 144B subsection 7 subclause 7, where a discretion is conferred upon a judicial authority whose decision has civil consequences, the word may denotes discretion should be construed to mean a command. So even in the pre-amended scenario, even if the wordings were may, personal hearing was declared as mandatory by Delhi High Court. So these two are the cases. These are the cases where personal hearing were declared to be mandatory to the So this is the fourth case. This is decided in Madras High Court. In this case, in a similar situation, assessee's request for personal hearing through video conference was not considered, and the court decided that it was violation of natural justice. And since the documents are voluminous, and since it couldn't be, the court decided that since the documents are voluminous, it would be difficult for the assessee to present it through National Faceless Assessment Center. The court decided that the assessing officer should come to the BSNL building tower at Chennai, and the case was the assessing officer, as mentioned by the Madras High Court, was present, and the case was heard. The next third topic would be regarding DIN, digital identification number. It's still an unsolved puzzle whether DIN is mandatory or not. It's not yet decided completely, and it is still an unsolved puzzle. In CIET versus Brandix Mauritius Holdings Limited, it is decided by the court that DIN is mandatory and DIN has to be issued by relying on the circular number 19 of 2019, and it held that the communication relating to assessments, appeals, orders, etc. without DIN can have no standing in law. So as per the judgment of the Honorable High Court, if Honorable Delhi High Court, if DIN was not issued, then the communication, whatever it is, it can have no standing in law. Then subsequently, a decision in a case relating to customs law, Madras High Court decided in assessee's favor that DIN is necessary. But the reason mentioned in Madras High Court is somewhat different to the decision of the Delhi High Court. Madras High Court stated that the intention of the DIN is to maintain a proper audit trail for all communications issued. It is to bring transparency and it is to make a proper audit trail, to make a proper trial and on what is happening and how it is implemented, and for complete transparency is the base of the introduction of DIN. The Madras High Court held that, I will read the exact wordings. The thrust of the exercise is to ensure that every communication issued by the state, including emails, must contain an authorization. The move is a progressive one backed by the avowed objects of transparency and accountability, the crying need of the day. When I have pointed out two cases where DIN was stated to be mandatory, in another case held by Madras High Court, in the context of international law, I'll not be going into the facts of the case. I'll be sticking to the DIN part of the case. In this case, order under 263 was passed, and on the next day, DIN was attached to a notice and it was sent to the assessee. The court held that as per para 5 of the CBDT circular 19 of 19, the communication issued manually can be regularized within 50 days of the order passed, and further relied on the para 7 of the order that prior to issuance of circular, the income tax authority shall identify such cases and shall upload the notice on the systems by 31st October 2019. Para 7 would not be applicable to the case before us. And regarding para 5, the wordings in the circular was that para 5, when it will be applicable, when it can be done is when exceptional circumstances under section under para 3 was present in a case, then para 5 can be used to regularize within 50 days of its issuance. So para 3 has to be satisfied first for para 5 to be introduced. But in this case, regarding para 3, it wasn't discussed in this case, but the court decided that DIN was not mandatory for an order to be considered as a valid order, and it decided against the assessee that DIN is not necessary.
Another 5 minutes, Girish.
Yes, sir. This is a case where everything we have seen now would be present in this case, including non-application of mine by NAFAC. The submissions of petitioner in this case was that, first I'll introduce the facts of the case. Assessee deposited some 3 crores in his bank account, but somehow it got into the respondents portal that Assessee has deposited 13 crores to his account. So the Assessee received notice for payment of 13 crores for providing source for 13 crores. But however, Assessee had deposited only 3 crores, and he replied to all the notices stating that he deposited only 3 crores and not 13 crores, and he provided source for the 3 crores. But the Faceless Assessment Center, however, sent further notices and confirmed the addition of 13 crores. This came before the High Court, and the petitioner submitted that National Faceless Assessment Center is total failure, and the inside portal of the department has been made to cause harassment to the assessee. So it clearly explains that the whole argument of the petitioner that the NFAC itself is a total failure and it should be scrapped, and due to the harassment faced by the petitioner. In this case, after explaining that 31 crores was not deposited, 13 crores was not deposited and 3 crores was deposited, and when it was not recognized by the respondent, the assessee even asked for personal hearing to explain his case. But citing the reason of limitation on 31st, the last show cause notice was issued to the assessee on 25th asking for his submissions. The assessee asked for personal hearing on 26th. Well, he asked for 1 day to explain his case, since till now NFAC has not understood the fact that 13 crore was not deposited and only 3 crores was deposited, and source will prove the 3 crores. But still the respondent number 4, who is NFAC, denied the opportunity of personal hearing, citing the reason that limitation was going on to expire on 31st. Even if he had 5 days time, he decided to do that. After all the replies submitted by the petitioner, the NFAC failed to look into the submissions made by the petitioner. He made up his mind that he is going to confirm the addition of 13 crore 67 lakhs 24,000, and he went on to confirm the addition of 13 crores 67 lakhs. In this case, the Allahabad High Court decided that the judgment, decided that the respondents have acted arbitrarily, and it decided that the respondent should be fined with a cost of 50 lakhs. But later, the first respondent, represented by ASG, after all their pleadings and prayers, the cost was reduced to 5 lakhs in a quantum hearing posted subsequently. So that will be my submissions on cases decided by SCN on video conferencing and DIN. These are the suggestions which could be feedback options could be given after completion of a submission or after completion of a hearing, so that at least the assessee would be satisfied that there is some progression happening in the NFAC. Because the question now is whether NFAC would be in the future or not is not the question. NFAC would be there in the growing technological era, in this electronic era, which is predicted to be moving into intelligence era. It is 100% necessary that we should be savvy with the technologies and everything related to that. So if any feedback can be given or if anything can be improved on NFAC, that has to be looked into from now on. And these are few of the suggestions that I found on the internet that I wanted to share.
Thank you, Girish. Nice and good maiden attempt by you. And one interesting point I want to share with you, the young lawyer, even though he attacked indirectly the decision of the Madras High Court, he put it very nicely that Madras High Court has missed the subsection, the clause 3 of that circular. Very nicely put. Thank you very much, Girish.
Thank you.
Now, the two young professionals from Delhi, part of Cyril Mangaldas, Amarchand Mangaldas, they will take over. Before they take over, Tangadurai and Reema Arya, I want to, I have gone through that their CV. One interesting point I noticed from their CV, what they have stated while they are explaining their experience. One, Mr. Tangadurai has stated, I quote, he is also involved in representing, strategizing the cases before the tax authorities. Strategizing the cases before the tax authorities. That is more important nowadays. That is required, and that is, I can put it, we can call it as one segment of an art by appearing before the courts. So now I request Tangadurai and Reema to take over. Your time is 40 minutes. That is mergers and acquisitions, interesting issues.
Thank you, Sridhar sir, for the very nice introduction. And we appreciate on behalf of the entire Cyril Amarchand Mangaldas team for enabling us to present a session on M&A tax issues. So we will like to share the PPT right now. And in the meantime, so our firm specializes in M&A deal. Of course, we deal in tax litigation and general litigation as well. We provide full service. We are a full service firm. We are engaged in. We are a full service firm. We advise from structuring till the till the execution of the deal. From corporate law perspective, from foreign exchange law perspective, and as well as from intellectual property law and everything. So basically, we advise investors or private equity investors when they pool the money and invest in.
Tangadurai, we are aware of Cyril Amarchand Mangaldas, your popularity, your role played in various fields. Come to the issue on hand.
Yes,
topic on hand.
We are not able to get the PPT, so just that's why I was just taking some time to. Can you see the PPT right now?
PPT. You please scratch your screen first. That is shared, but
you can't see the PPT. My screen is getting shared. Okay, fair enough. I don't think the screens are visible to the people. So moving on to the topic, basically M&A transaction. When we talk about M&A transaction, there are 5 kinds of.
We are getting it now. We are getting it now.
Yeah. Yeah, thanks. We'll move to the next slide. So when we talk about M&A transaction, there are basically 5 types of M&A transactions. One is a share sale, and the second is a slump sale, and third is itemized sale, and fourth is merger and demerger. Before going deeply into each of these types of transaction, first we will just let you explain a little bit about what is a share sale, so that it becomes easier for the audience and everyone on board or on the same page. Share sale is particularly when a buyer, when an investor is interested in acquiring a particular company, they will enter into a deal with the existing shareholders of the company. And they will, there will be negotiations between the buyers and the seller to determine the values of under commercial consideration regarding the same. And once that is done, there will be an execution of agreement called share purchase agreement. And this is typically called a secondary transfer because the company is not involved in this deal. It's a deal between the buyer and the seller is always the existing shareholders. Sometimes the investors would potentially would not want to pay out the seller in full. So they would want a skin in the game of the sellers, of the existing shareholders. So instead of paying out the sellers, they will invest directly into the company, for which purpose the company will be asked to issue shares directly to the investors. So that will be called as a primary transaction where there will be share issuance. So this is the reason. A share sale is one of the most common types of M&A transaction. Out of 100 deals, you will find 90-95 deals dealing with share transfer, and the next one is slump sale or slump exchange. This is a deal between the investor, that is the buyer, and the company directly. Basically, the investor will not be interested in buying buying out the company or the shares of the company. Rather, he will be interested in a particular business of the company. For example, if the company is having two different kinds of business, so the investor will only look into one kind of will be interested in one particular business. So then he will enter into a slump sale agreement, which is also colloquially called business transfer agreement. So that will be executed between the company and the buyer. And the slump exchange is slightly similar to slump sale because here again the investors are interested only in the business, but instead of giving cash consideration back to the sellers, that is the company, they will issue their own shares. So it's a kind of an exchange. So there are dual transactions taking place through a singular instrument. And another one is the common itemized sale, where the buyer is not interested in either the company or the business, but they are only interested in a particular few assets of the company. So that will be considered. So then they will have an asset sale agreement, which is whatever the if it's an immovable property, then it will have to be registered with the local. Sub-register office. If it's any other assets like machinery or equipment, then probably GST and all will get attracted. And the last two types of M&A transaction are more like merger and demerger. These are mostly code-driven transactions, as in it cannot be. The deal cannot be settled between the buyer and the seller. The courts will have to verify the transaction and bless the transactions. Only then the merger can take place, because it is a code-driven process. It's obviously time-consuming. It may take anywhere between 6 months to a few years, couple of years also it may take. And merger and demerger are mostly are part of internal reorganization. Mostly that's the case because in a merger, there will be two entities. One entity will get merged into another entity, and the merging entity will get extinguished. So the resulting entity will have to issue shares to the shareholders of the merging entity. So basically, the shareholders are going to more or less remain the same. So it's not kind of a situation where investors are coming into picture. It's more of the internal reorganization between the business. Demerger is also similar. Instead of merging a couple of companies, a particular company will demerge and form a new company. Here also the shareholders shall have to remain the same. For both the companies, at least 3/4 of the shareholders should remain the same to get the tax neutrality. So these are the snapshot of the different kinds of M&A transactions. Now that so before going into detail about what are the technical aspects or tax aspect of each of those transactions, I would like to briefly touch upon the commercial the key driving aspects for an M&A deal. Of course, the number one is always the commercial consideration. Basically, when an investor is interested in a particular business, so they will be looking at the business and commercially evaluating. If it's a deal between third parties, it becomes straightforward. The buyer will offer a price and it will boil down to negotiation and the deal will get consummated. But if it's between the related parties, the commercial considerations will take in a different form altogether. For example, if a group company has a couple of companies, one is, say, for example, engaged in the business, manufacturing of automobiles. Another company is being involved in the manufacturing of spare parts. And if a particular company is not doing very well, there's no point in continuing with the business, but there will be technology lying with the company which is not doing very well, and there will be manpower, and there will be assets lying with the company. And in order to integrate both this, in order to utilize the talent pool and the assets lying with the not so good company, the parties, in order to unlock the value, they will enter into a merger so that the synergies, the talent pool and the technology will get synergized, and it will be appropriately used. Otherwise, if it's a service, if without merger, if the profit making company is going to get the services of another company, then it will have to pay service fees and other things, and plus it's a lot of compliances. So therefore, to unlock the value for the company, the commercial consideration is to merge these two entities and form a single entity. Sometimes another interesting aspect is sometimes the M&A deals are done not just to unlock the value for the company, but also unlocking the value for the listed company, for the shareholders. For example, if there is a listed company, and if it's having two different businesses, say manufacturing and a financial services segment, and both of it has a separate set of employees, and they were able to maintain separate books of accounts for each of them, then it becomes imperative for the shareholders to create value for the shareholders. They will spin off the financial services company and form a separate financial service company and list the same as well. So therefore, they will have the opportunity to list both the entity, both the companies, and it will potentially unlock the value for the shareholders as well. And so once these commercial parameters are set, then we go into the tax aspects. So when in a third party deal, when a buyer is acquiring a business, the primary tax consideration is the tax due diligence. Here, the buyer will wear the hat of the assessing officer and verify the tax returns of the target company, the company which the buyer is interested to buy, and examine the different the different positions taken in the tax returns, whether those positions are very aggressive, because sometimes if they claim some expenditure abundantly, then there is a possibility, there's a very good possibility that the tax authorities may while scrutinizing the cases, it will get disallowed. So these kind of tax risks will have to be carved out or identified in the due diligence process, and there could be existing litigations lying against the company. And when a buyer is acquiring the company, he will put the value based on the commercial projections, the future value, earnings that the company target could provide for the future. But if there are legacy pending tax issues attached with the company, that is going to deter or bring the value down of the target company. Therefore, it is important for the buyer to verify the existing tax litigation and analyze the possibility of success before the taxation authorities or the higher appellate courts. And if it's very aggressive, then the buyer will have to take into consideration when he's finalizing the final sale consideration. If there is a substantial risk, probably the sale consideration will have to be reduced. And this is where it gets very critical, because the seller will not be interested in reducing the sale consideration. And so though it will become a commercial call, it will depend on how badly the buyer wants to buy or how badly the seller wants to sell. But typically, if it is a very high risk situation, parties usually consider an escrow account wherein a part of the sale consideration it will be kept in a separate account in order to meet the future tax liabilities that could arise from the past tax litigations. Because once the company is bought by the buyer, then the tax liabilities will be on the buyer. So it is imperative for the buyer to have some cushion. And this needs to be done at the time of M&A deal itself. Like it can't be negotiated once the deal is done. So when the deal documents are consummated, all this existing litigation will have to be separately notified. And a separate indemnity shall also have to be obtained. And if the risks are very high, then a part of the sale consideration will have to be kept in an escrow account. And probably before even the next consideration is the tax cost. So before even when the M&A deal gets consummated, or before when they start in the drawing board, the first thing is the transaction cost. Because when the seller is making interested to sell off the business, obviously there will be capital gains tax. So the remaining will only be his net consideration which he can enjoy. So therefore, the transaction cost will be examined very carefully. And for examining the transaction cost, which is like capital gains tax, and there are anti-avoidance provisions incorporated into the act, like 56(2)(10) and 56(2)(7)(b), which basically says if there is a transfer of if a particular buyer is getting a share for a value lesser than the fair market value, then the differential value will be taxed in the hands of the buyer. So there is a transaction cost risk is for both the buyers and the sellers. We will deal with it a little more in detail when we talk about the share sale, and this will have to be considered. And obviously GST, when we are talking about M&A, the business is getting acquired. Obviously the business will the transaction itself may create some GST. Usually when we look at it, there is no GST on share sale. It is completely exempt. And similarly, there's no GST on mergers or demergers. And slum sale business transfer also, there is a specific provision under the GST laws which exempt the implication under the GST laws. However, if it is an itemized sale is when the buyer is interested in acquiring a particular machinery or something, then there is a possibility of GSTs, and the applicable rate will be levied. And another very, very important the tax consideration for an M&A thing is tax savings. See, multiple times we have seen a number of deals where the deals are driven primarily on account of tax savings. Especially, there are three kinds of tax savings. One is carry forward of losses, another one is unabsorbed depreciation, and the third one is paid payable issue, as in when the target has obtained loan, it can claim the interest as an expenditure only when it's paid, not at the time of accrual. So therefore, this is a very live issue. And going a little more deep into tax saving, when it comes to carry forward of losses, this typically happens in a internal group restructuring. Recently, it happened in Honda merger also. Honda Cars and Honda Motors got amalgamated into each other. If you look at it, the Honda Motors entity had a substantial loss, like around a few thousand crores, and whereas Honda Cars was making profit. And Honda Motors was not only making motors, but also undertaking several loss-making businesses like spare parts and others, which it was not able to supply to third parties, and it was consumed entirely in-house. So therefore, one entity was loss-making. So when there is an amalgamation of this company, as per Section 72. Post the amalgamation, the new entity will get a fresh life. The losses will get a fresh life of another 8 years. Plus, now that the profit-making company also has these losses on going forward basis, whenever every year there is a 30% or 25%, whatever the tax rate applicable to the company, there's a straight 30% tax advantage that the new resulting company will get, and this is primarily one of the main tax considerations for all these mergers, to make use of the the carry forward loss benefit, which is provided under section 72. And having said that, there is also a restriction. That is why it is always used only in internal group restructuring, because section 79 of the Income Tax Act puts a restriction that if there is a change in shareholding to the extent of 51% in the loss-making company, then the moment there is a change in shareholding, then the losses will get lapsed, right? So therefore, this transaction, the carry forward loss benefit will not be available in a share sale. So typically this is used only in merger transaction. However, when it comes to unabsorbed depreciation, the concepts are the same. Unabsorbed depreciation, simply put, there are depreciations which have been accumulated over the years in the target, but it's not been utilized only because the company was suffering losses. So it's a separate bucket of another nomenclature for the losses. But here the catch is section 79 does not put any restriction with respect to unabsorbed depreciation. So therefore, it could work very well in a share sale as well. And so the third type of tax saving, as I've explained earlier, it's a paid payable issue, especially in a loan transaction, when unless the interest is paid, the target cannot claim it as an expenditure. So when the company in the target is being sold, obviously the new buyer will pay it off, right? When he pays off, he is going to get the benefit for the interest accrued before the transaction is consummated. So therefore, the buyers, technically the sellers, will have the option, to negotiate with the sellers and at least pass on the tax savings as and when the seller realizes, as and when the buyer realizes it post acquisitions, right? These are some of the important tax consideration. And the last one is succession liability. Succession liability, when it comes to what is succession liability? So post the transaction, whether the tax liability pertaining to the pre-closing period, whether will it pass on to the buyer or not? In a share sale, it will 100% pass on because the target company remains the same. This is a separate individual entity. So therefore, there is no restriction for, there is no exemption for it. But in a business sale, that is a business transfer or slump sale, that is the buyer is just buying the business. The company post the acquisition also lies with the seller. So therefore, the tax liabilities are always attached to the PAN of the company. It is not, even though there could be multiple business within the company, it is not, the tax liabilities are not going to be attached to each of the businesses. It is going to be attached to the company as a whole. So there is the succession liability in a business transfer or itemized sale is not possible. However, with respect to business transfer, there is one archaic provision, section 170, which we will deal with it when we talk about a slump sale. And so moving on to the next slide. So now that we have seen what are the key drivers for key drivers for the share for the M&A deals, we will also briefly touch up. We will also quickly go through the tax implications. I don't want to take a lot of time. There's only 10-15 minutes left. And when it comes to share sale, obviously the primary condition, because shares are considered as capital asset under section 247, therefore any transfer of a capital asset will attract capital gains under section 45, and the tax rate for the capital gains are provided under section 112, which the rates are varied from 100 to 40%, 10 to 40%. The non-resident, if it is a non-resident seller, the income tax provisions provide a beneficial treatment when compared to resident sellers. It says if a non-resident seller sells a particular share, sells the shares of an Indian company, or sells the shares which are subject to tax in India, so then he can get a beneficial tax rate of 10%. Of course, the indexation benefit will not be available in such a case. However, the risk for the non-resident seller is, if it is a short-term capital gain, then the tax rate is 40%, because the general applicable rate, the short-term capital gains are always taxed at a general applicable rate. And the applicable rate for a non-resident company is 40%. And when it comes to the resident seller, the tax rates are 10%. and tax rates is 20%, and the applicable rate in terms of short-term capital gains is the 25% or 35%, whatever the company is subjected to. And the rates are of course subject to tax treaty benefits. Of course, from 2017 onwards, there are no tax treaties are giving the benefits. For example, Mauritius, Singapore, and Cyprus, which had earlier given complete tax exemption for the sellers based out of these entities. Right now, there is a grandfathering clause. Of course, if the shares are acquired before April 1, 2017, then even if they sell today, they will still get the benefit, but they will not get the benefit if they acquire the shares post April 1, 2017. And when it comes to the tax treaty benefits, then we will have to carefully analyze the limitation of benefit clauses, because there are a lot of complications around it, surrounding it. Although Singapore Treaty also has a grandfathering clause, because of the limitation LOB clause, we have seen a number of deals being picked up by the tax authorities and questioning that the entity set up in Singapore is just a shell entity and it does not have any business, and therefore the benefit of the capital gains should not be given. And when these considerations are part of the M&A deal, then it becomes very, very critical. Because the buyer will not want to take out any of the obligations of the sellers, because if it's a non-resident seller, you will appreciate that as per the Income Tax Act section 195, if anybody is paying money to a non-resident and that non-resident, that particular payment is taxable in India, so then the obligation shifts to the payer. Here it's the buyer. He will have to withhold the taxes. And failure to withhold the taxes will attract withholding tax proceedings, and the penalty rates and all are the same. So then it becomes heavily negotiated, and whether particularly with respect to Singapore deals, we need to see if we are representing the buyers, we need to be extremely careful because the sellers are going to go gung-ho about the tax benefits and they will not want the buyer to withhold any taxes. So all this consideration will have to be carefully looked into. And then there is another beast called indirect transfer post the Vodafone, because here, if it is said to be, of course, the formula provides under section 9, which is very, very clear, which is either the consideration exceed 10 crores and the value of the foreign company derived from the assets in India for more than 50%. So, and the formula, the rules, 11 new AAC are all very clear. So once the valuations are done, then we will get to know whether indirect transfer is applicable in the instant case, in which case the buyer will again get the withholding tax obligations. And there is a new provision a couple of years ago, they were called TCS. They said 206C subsection 1H, which basically said, on any transfer of goods, on any sale of goods, there should be TCS at the rate of 0.1%. Although the amount is very less, sometimes what happens, the non-residents will not want to have any exposure with the Indian tax authorities at all. So therefore, if he has to collect this TCS, then he will have to get a PAN, and then he will have, once the PAN is obtained in India, then the transaction comes under the radar of the income tax authorities. So all this gets a little complicated. And TCS basically says goods, and the term goods has been loosely defined. I mean, the 206C does not define the term goods, but generally goods has been defined in various other provisions like Sale of Goods Act and the GST provisions to include shares as well. That's where it is coming into the ambit of. Otherwise, it's a capital account transaction. It should not come out of it. So there's a huge controversy surrounding it. But the industry is slightly moving towards a position that it's better to do this compliance in instead of taking an aggressive position. So even in a share sale, right now we are seeing a lot of deals that if there is no TDS, then TCS will have to be collected at 0.1%. And there is, of course, fair market valuation norms, section 50 CA. These are specific anti-avoidance provisions. And there is, of course, general anti-avoidance provision, GAR. These two sections, 50 CA, 56 to 10, is basically simply put, they are saying if somebody buys a product for a value which is lesser than the fair market value, then the differential amount will be taxed in the hands of the buyer, number one. And it's a double whammy provision because the seller also will get taxed. For the purpose of computing capital gains, the actual consideration will be ignored. Instead, the fair market value as determined under Rule 11 UA will be considered as the sale consideration. Moving on, I think I'm running short of time. So simply put, so carry forward of loss benefit, as I've said, it is not available in a share sale because the moment we exceed the 49% threshold, then we will not be able to get it, and there is no GST on the share sale. And when it comes to documentations, typically if there is a withholding tax obligation in the hands of the buyer, then all these conditions, there will be condition precedents should be incorporated into the SPA, into the share purchase agreement before the deal is consummated, because these are going to be very critical, because we have seen a lot of time, once the deal is done, the buyer and the seller will not see eye to eye. They will not share any details. So if there are any obligation, the seller is not going to, graciously come forward to take forward the obligations. And the buyers are going to be extremely aggressive in extracting as much money as possible. So all these clauses will need to be thoroughly negotiated. And we have seen deals, for example, this SR Rosneft deal, where the deal worth is around a lakh of crores rupees. And the tax clauses incorporated into the SPA were running into several 150 pages. With each of the positions were thoroughly discussed, negotiated, and incorporated into the SPA. And there's also, I don't want to go very deep into everything else, but I want to touch on Section 281. Section 281 is basically gives power to the tax authorities to call the deal as void deal. If the seller enters into a SPA or transfer any of his asset pending tax litigation. So basically, when the seller has some pending tax litigation and he enters into any deal to transfer his assets, then if the tax authorities have the power to call the entire transaction as a void transaction, the only way out for the buyer is to get a no objection certificate from the tax authorities. And as we are all aware, the tax authorities will take their own sweet time, and there is no limitation provided under Section 281. So it's almost next to impossible to get a clean chit certificate from the tax authorities before the deal is consummated. So these are the risks which I wanted to highlight. Now we will quickly finish slump sale.
Okay. So quickly moving on to the next mechanism, which is a slump sale. So in a slump sale, there is a transfer of an undertaking rather than transfer of shares of an entity. Here, it is important that the transfer of the undertaking is made on a going concern basis, and the assets and liabilities that are being transferred are not to be valued separately. So the transfer of the undertaking is on a lump sum amount, and separate values are not to be attributable to the assets and liabilities that are being transferred. The term undertaking has been defined under the IT Act, so it is important that whatever is being transferred has to constitute a business activity as a whole. And it should not happen that it's just a combination of assets, but taken together, they do not constitute a business activity. So in any documentation of a slump sale, it is important that the right words are used, so that and also in actual also the whole undertaking has to be transferred, so that the beneficial rates available for the slump sale can be taken. It is important to note that in case this undertaking test is not satisfied, then the taxability is going to be governed as per a itemized sale. From a tax perspective, when we go to the tax implications in case of a slump sale, the capital gains are there's a specific section 50B which treats the taxability of a slump sale, And it says that it's a capital gain transaction which is to be computed by reducing the full value of consideration from the net worth of the undertaking. Net worth of the undertaking is basically the assets minus the liabilities, or the capital plus the reserves. And the full value of the consideration, while earlier it used to be taken from the book value, through a couple of years ago, the amendments were made to cover wherein if the undertaking includes land and building or shares and securities, then it is important to value them at their fair market value as per the prescribed norms. And in that case, the fair value of full value of the consideration will be taken as the higher of this actual amount received, or the book value subject to the fair valuation norms. In terms of the tax rates, if the undertaking has been held by the transferor entity for 36 months or more, then the tax rate is the beneficial long-term capital gain tax rate, which is 20%. Otherwise, the short-term capital gains tax rate applies, which is the normal tax rate applicable to the transferor entity. When it comes to the carry forward, obviously when as we explained earlier, the carry forward of losses are at an entity level, and in this case only an undertaking is being sold, not the whole entity. So the carry forward of tax losses or unabsorbed depreciation is not allowed in this case. GST again is not applicable in case of a slump sale. When it comes to succession liability, so there's a specific section 170, which prescribes that in certain situations wherein a predecessor, the seller, cannot be found, then the tax authorities are empowered to go against the successor, basically the acquirer of the undertaking, and that person can be held accountable to pay the outstanding taxes for the year in which the slump sale has taken place, and one more preceding year from that year. And apart from this, the tax authorities cannot go to recover the taxes of any other past years, but there are just they have the access to recover the taxes only for these 2 years. When it comes to itemized sale, the term itemized sale is not really defined under the Income Tax Act. But if the undertaking test in case of a slump sale is not satisfied, then you by default come into the implications of an itemized sale. Or alternatively, there could be a piecemeal distribution, piecemeal sale by any entity of its specific assets. Unlike slump sale, here you will have to ascertain a specific value at which you are selling, and there is no specific transfer of liabilities in case of itemized sale. As compared to slump sale, the main difference is that in case of a slump sale, you are not allowed to cherry pick your assets and liabilities that you want to sell. But here in an itemized sale, you can actually cherry pick whatever you want to buy. And if you don't want to buy any specific asset, then you have the liberty to not buy it. And you will then have the optionality to actually buy the relevant asset that is required for the business and to actually achieve the synergies in that way. And accordingly, buyer will specifically pay for that specific asset, and the accounting provisions have to be taken care of. When it comes to the taxability, that is dependent on the type of asset that is being sold. So when it comes to depreciable assets, they are deemed to the depreciable assets could be a machinery or any other asset of the business, and which are depreciable, obviously. And the capital gains here are deemed to be short-term capital gains, irrespective of whatever time period the transferor has held such depreciable asset. And the gains are computed by reducing from the sale consideration the opening WDV plus the actual assets acquired in that year. And when it comes to non-depreciable assets like land, the gains are computed by reducing the sale consideration from the book value of the asset being transferred. The period of holding in this case will depend on the provisions that are there in the Act. So if you are selling before completing 2 years, then it's a short-term capital gain taxable at the normal tax rate. But when you have held it for more than 2 years, then it's long-term capital gain taxable at 20%. Other than this, if a business asset, for example, a stock or inventory is being sold, then again, it is considered as sale of your considered as your revenue from operations, and the gains are taxable as business income at the normal tax rate applicable on the seller. Here, it is important that because each and every asset is being sold separately, the GST implications will have to be analyzed, and the GST rate could be as high as 28%. Sorry. It is important to note that there are some fair valuation norms attached for some specific assets. So in case of a land and building, you cannot sell it below the fair market value. And similarly for shares and securities, they cannot be sold below the fair market value. There are specific norms to identify the fair market valuation of these specific assets. Carry forward of tax losses and unabsorbed depreciation, again, not allowed. And withholding tax could apply depending on the type of asset being sold. So again, for land and building, there is a specific section under which the withholding applies at the rate of 1%. And for shares and securities, they might get covered under the definition of goods. So again, the provisions of withholding will have to be analyzed. Succession liability here does not apply, because you are actually purchasing just one asset. So there is no risk of the previous the transferor's tax liabilities being attached.
And I think we're almost time, but I will just quickly run through what's merger and demerger, as I think I've enough elaborated when I explained about the Honda merger or not. So basically, a merger is a tax neutral transaction. Tax neutral when we mean like when there is a merger, there is two companies which is merging into each other. So there's a transfer of asset from one company to another company. That is completely tax neutral, as in the section 47 gives a clear exemption for that. Similarly, the shareholders of one company are surrendering, or their shares are getting extinguished. Extinguished, as you know, section 247 includes extinguishment as considers or also being considered as transfer. So that is also exempt under section 47. And so basically it's all exempt. The only requirement is the conditions should be met. The conditions are the resulting company should be an Indian company. We'll go to the next slide. And the shares of the shareholders of the resulting company should be the same as that of the amalgamating company. Basically, at least 3/4 share of the company which is going into the bigger company, these shareholders of the smaller company should become shareholders of the resulting company, right? And it's a tax neutral transaction. As I've explained, there is a huge benefit of carry forward losses, and this is the primary reasons why internal restructurings are always towards the merger. We will move like fair market. Demerger. In an amalgamation, there is one company will merge into another company, and then the first company will get extinguished. In a demerger, there's a single company which has two business, and one business will get born out of the old company, and the new company, the shareholders of the new company should also be the shareholders of the old company. So basically, when the new company is formed, the shares should be issued to the shareholders of the old company, minimum 75%. And this will also have to meet the undertaking test, which we had discussed while we are discussing about the slum sale, and it is also completely tax neutral. And of course, there is also carry forward tax loss benefit in demerger as well. However, in a merger, we get a fresh life of 8 years. Here, we don't get a fresh life of 8 years. Rest or same. Yeah, that's about it. Thank you. Thank you for.
Thank you.
Thank you, Mr. Tangadurai and Ms. Rima Arya. It was a very good presentation with explaining the tax implications also of mergers. And now I have another announcement to make. We have amongst us.
Vasu, 1 minute.
Yeah.
Before you say, Tangadurai, please share the PPT if possible later on.
Sure, sir, we'll do that.
Yeah.
Yeah, thank you, sir. We have for our meeting today 5 new entrants to the Revenue Bar Association: Mr. Suhrat Parsardi, Mr. Banu Shekhar, Ms. Amrita Satyajit, Ashwini Vaidyalingam, and Mr. Shankar Ganesh. I welcome all the 5 of them to the Revenue Bar, and hope you continue to attend all the meetings. Thank you. Thanks to all.